post the questions on the chat box, which will be taken up by the professor depending upon the time at the end. Also note that the attendees will not be receiving any e-certificate for this lecture. To begin with the lecture, I request our Professor of Eminence and in-charge registrar, Dr. Bhavani Prasad Panda, to give the introductory remarks. Thank you.
Good evening. Are you able to listen to me? Am I audible?
Yes, sir.
1 minute. It's a pleasant evening for a wonderful lecture. We have been eagerly waiting from Professor Andrew Mamo, and I welcome the whole of the guests and particularly I must congratulate our Professor Kiran for organizing this wonderful function, particular program, where Professor Mamo is going to address the students on philosophy and law. As far as I have seen his CV, I find it very interesting. We've been eagerly waiting. The topic on law and philosophy is always an ever interesting topic for the students of law anytime, because the topics which Professor Mamo has excelled is semiotics of law and the language of the law and the right perspective of the law. So these are some of the things which should endure the students right from the very first year until the advancing years of profession, as well as maybe in a practice or maybe as a legal academician. These particular topics are really, very much in need, very much in way of thinking. They do really thought-provoking when we keep thinking about what should be the real language of law, what should be the articulations, what the judgments they explain, what are the semiotics in these particular things. And I'm eagerly waiting, equally with all of you people, to listen to Professor Mamo as far as the today's topic is concerned, the soft law and the legal philosophy or the philosophy of the law, whatever it is. So I welcome, and I'm very much happy to be part of this particular program. And we look forward, I'm sure the students of this university will take this opportunity for enhancing their scholarship and add to the knowledge, the learning study. Thank you for giving this wonderful opportunity. I wish to, along with you people, to listen to this course. Thank you.
Thank you so much, sir. I request Y. Amrita to take over to introduce our guest.
Hello, everyone. I feel elated to introduce Professor Andrew Marmot to everyone tonight. Joining us today is the Jacob Girls Kuerman Professor of Philosophy and Law. He obtained his first law and philosophy degree at the Tel Aviv University in Israel and a philosophy doctorate at Oxford University, UK. He taught as a professor of law for 10 years in Tel Aviv University. He was a professor of philosophy and Maurice Jones Junior Professor in Law at the University of Southern California. He was visiting professor at Benjamin Cardozo Law School, New York, University of Chicago Law School, University of Virginia Law School, and University of Southern California Law School. Professor Andrew was a member of the Israeli Bar Association and worked at District Attorney's Office, Central District, Israel. His research interests cover philosophy of law, moral, social, and political, philosophical, and the philosophy of language. Marmor has published dozens of articles such as Legal Positivism, Still Descriptive and Morally Neutral, and Philosophy of Law, a reply to critics. 6 books monographs, whereas his books include Social Conventions from Language to Law, Philosophy of Law and the Language of Law, and the Rotlick Companion to Philosophy of Law. His books and articles have also been published in numerous translations, including Philosophy of Law in Chinese and Judicial Review in Israel, Mishpat Umishal Law and Governmental in Israel in Hebrew, and also in Spanish, Portuguese, and Italian languages. On a final note, Professor Marmor is the founding editor of the Journal of Ethics and Social Philosophical Legal. legal theory, ratio juris, and also International Journal for the Semiotics Law. His Pure Theory of Law and the Nature of Law are the two entries of Stanford Encyclopedia of Philosophy. He is presently working on the topics Two Rights of Free Speech and Norms of Reasons. We are very glad to have you for this lecture. Thank you, sir.
Thank you, Amrita. Professor Andre, you can take over.
Sure. And I will begin then with the specific topic. So I don't know how much you know about international law. Not that I know that much, but there is. I'm not an international lawyer. I'm just using it as an example. So there is a really interesting, fascinating development in international law in the last few decades. It's been there before, but it's more pronounced in the last few decades. That many regulations and treaties and contracts in the international domain are explicitly non-binding. So international law has developed a very wide array of legal instruments. And I explain in a minute what I mean by these legal instruments that explicitly avoid the imposition of duties, of obligations on the relevant parties. Now, there is some debate in international law whether this stuff is really law or not. It's often referred to as soft law. I'm not interested in that debate. Whether it's law or half law or quarter law, who cares? What I'm interested in is understanding the rationale of it, okay? Understanding from the perspective of practical reasons what's going on there. What's the point of having a legal instrument that applies to certain parties, but in a non-binding way, without imposing any obligation? Now, how do we find soft law? How does it manifest itself? Well, there are two main categories, which I call vertical and horizontal. Vertical soft law, or we can call it top-down soft law, are authoritative directives issued by various international agencies or authorities applying to certain parties, sometimes to all states. So these are top-down or vertical authoritative directives. They can come from the United Nations General Assembly. They can come from various international courts or tribunals. They can come from various international arbitrators. There is a very wide range of international authorities that issue directives that are non-binding. Okay, so I call that vertical soft law. Then additionally, we have horizontal soft law, which are basically treaties, contracts between states. And many of them, in fact, most of them recently, are non-binding. So you have a bunch of states entering into a treaty, sometimes a very, very detailed, serious treaty. Yet they make it clear that the treaty is not binding, it's not obligatory. If you want one example from recent times that is very famous, the 2016 Paris Treaty on Climate Change, that is considered to be a major step in combating global warming. And most countries in the world sign off on it, is non-binding. It's not obligating the parties. Okay. So what I want to understand is what's the rationale of it. Okay. Now there are two kinds of questions one can ask about these things, right? And I'm interested in only one of them. one can ask an empirical question. Why is it that countries or international authorities use these non-binding legal instruments? We can ask why, what are the causes, how effective they are, when are they effective, all sorts of empirical questions like that. This is not my concern. Okay? I'm not going to offer here a theory of why international agents engage in these non-binding instruments or how effective they are. I would just say in brackets that there is an enormous variety, an enormous range of effectiveness. Some of these instruments are not that effective, but many of them are. So parties abide by the non-binding legal instruments, even if they are non-binding. But that's not my concern. What I want to understand is the practical reasoning. I want to understand the rationale. What is it that parties are actually doing when they engage in these forms of soft law? So I'm going to start with the vertical model of soft law. So I'm going to start with the top-down authoritative directives that are non-binding. And I'm going to offer a rationale in terms of practical reasoning for it. And then I will try to show how the same rationale with an addition of another element helps us explain horizontal soft law. Yeah. So that's the structure of my argument. Now, let's start then with vertical soft law. Okay, so the idea is we have a practical authority, some agency or tribunal with authority in a certain domain. They issue a directive, some order, but they make it clear that the order is not binding. Okay? And the question is how to explain that. What's going on? Okay. Now, why is that a challenge? Okay. It is a challenge because that's not how we think about authority. So a traditional way of thinking about authoritative directives is that they are binding. They are essentially obligatory. If an authority tells someone to do something, then, and assuming that the authority is legitimate, then we would assume that the subject of the authority is under an obligation to comply, right? So how can we explain authoritative directives that are not obligatory? Now, here's the idea, and it sounds like kind of crazy idea, but I want to defend it. The idea is that authorities, in addition to issuing ordinary directives that are binding, are sometimes in a position to issue what I call authoritative advice. They can advise in an authoritative capacity. And that's the concept I want to explain. What is an authoritative advice and what makes it possible? So let me give you a couple of mundane examples of authoritative advice and then try to explain what's going on there. So suppose my dean at the law school tells me that he thinks that it would be a very good idea if I teach international law next year. He would have lost his mind if he did that, but that's a hypothetical, so don't worry about it. So suppose that he tells me, look, it would be good if you teach international law next year, or whatever course. Let's assume that the dean is in no position to oblige me to do that. You know, I'm too old for that. But he advises me to do that. Okay. Now, I want to say that it makes a difference that the advice comes from the dean and not from a friend of mine. friend can also advise me to do something. But the advice of the dean is different. Here's another example. I'm hoping it means something to you. So at least in the US, I'm assuming that in India as well, professors at some point get tenure, means they cannot be fired anymore. So everybody who starts an academic career is looking forward to their tenure. That usually happens after 5 or 6 years as an assistant professor. It's a big deal. So since it's a big deal, every university has guidelines. And what do you need to do in order to get tenure? Okay. And one guideline that I find really interesting, and I find it, every university I've been to, it's about the same. The guideline would say something like this. Publishing a book before tenure would be normally required, or it's generally expected that you have a book when you apply for tenure. So suppose we have an assistant professor, call him Jim, and Jim thinks, what the hell does this mean that it's normally required? Yeah? Well, he would come to realize very quickly that it's not mandatory. It doesn't have to. The regulation doesn't say you absolutely have to have a book, otherwise don't think of applying to tenure. Right? So he would think it's advised. It's a good idea to have a book, but not absolutely required. Okay, so that's an example of an authoritative advice. You want tenure, you better have a book, but you may get tenure without it. So we have lots and lots of these cases, right? We have tons of them in the employment context, right? Employer-employee relations, where authorities advise their subjects to do something, but don't quite require it. So that's the idea I want to explain, because I want to show that soft law, vertical soft law, top-down soft law, is a form of authoritative advice. Okay. Now, there are two challenges here. Yeah. Two serious challenges. One is that authoritative directives, by their nature, are directives. It makes a difference that the directive had been issued by an authority, right? Wishful thinking doesn't make authoritative directive. The say-so of the authority, practically speaking, in terms of practical reasoning, makes a difference. You have an authoritative directive when you say we have a reason to do something because somebody said so. Okay? The saying so of the authority makes a practical difference. So one thing we need to explain is how the saying so of a practical authority makes a difference to the fact that it's only an advice. What kind of advice is it that comes from the say-so of the authority? Here's the second challenge. Advice, generally speaking, does not aim to change the reasons for action that the advisee had prior to the advice. It doesn't create new reasons for action. When I advise my friend to do something, I don't intend to point out to my friend that because I say so, there is a new reason for action. What advice normally does is it points out to the subject, to the advisee, some reason that applies to them anyway. Right? So these 2 points taken together, the fact that the say-so makes a difference and that normally advice doesn't create new reasons for action, just points out reasons that apply anyway, make this idea of authoritative advice a pretty difficult one to explain, right? What's going on there? So in thinking about that, I was inspired by something that lawyers know very well, a phenomenon or sort of a legal instrument that we are all very familiar with. And it's called presumption, legal presumption. It's an interesting phenomenon. So what do we have when we have a legal presumption? What the law does when it includes a presumption is essentially determining something like this. The law would assume that if certain conditions apply, then something is the case. However, this assumption is rebuttable. Okay? So the law, for example, would assume that if condition C apply to an agent A, then A is an X. However, it allows A to show that he's not an X. In other words, what presumptions do, they shift the burden of proof. Right? They shift the burden of proof to the subject to show that certain conditions that generally apply don't apply to her specifically. Okay? It allows the agent to rebut the presumption. Okay? So what we have here is a combination, a disjunction actually, of two elements. A first order reason to do something or to be in a certain state, and disjunctive reason, shifting the burden on the agent to prove that the general presumption is rebutted, does not apply, or is defeated. Okay? So this is the legal instrument. But I think the legal instrument captures something that is very familiar and a certain type of reasoning that I call presumptive reasons. Okay? And I think that we have this structure of presumptive reasons in many cases. So what's a presumptive reason? Reason for action. It's a combination of two things. To say that R is a presumptive reason for an agent A to do something, to file, means that R is a defeasible reason for the agent to file, a reason that can be defeated under certain circumstances. However, it also says that if the agent does not file and claims that the reasons to file were actually defeated in her case, then it is the agent who needs to show that. The agent needs to prove or to show that the reasons were defeated. In other words, the structure here is something like do or explain. Right? You have a reason to do something, so do it. Right? Or if you don't, explain why you didn't. Okay? Now, here's an example. Outside the legal context, of course. Suppose I have a very good friend and I need help with something fairly trivial. So I tell my friend that I'm seeking their help with, I don't know, helping me move a heavy piece of furniture or something next Saturday. Okay. Now, we assume that given our friendship, my request gives my friend the reason to help, right? Otherwise, he wouldn't be my friend. We also know that the reason is defeasible. Maybe my friend has other important engagements next Saturday. Okay. Suppose he does. Suppose he cannot help me next Saturday. He already promised to do something more important. The point is that it's not enough that the friend actually has reasons that defeat the reason to help me. He needs to tell me about it. Right? He can't just keep quiet, not comply with my request, and think, well, that's okay because I have a defeating reason. So the structure here is do or explain. Right? Help me, or if you can't help me, explain to me that you cannot. Okay? That's the expectation. Okay? So we have presumptive reasons for action, generally speaking, when there is an expectation to comply with the reason for action, or else explain why you cannot. And of course, the explanation has to be true, otherwise it won't work. So my claim is that authoritative advice has the structure of presumptive reasons. When an authority advises a subject to do something, the expectation is that the subject do it, comply with the reason that has been pointed out to him, or else explain to the authority why the reasons are defeated. Okay? Do or explain. Now, you may wonder, what goes wrong if a subject flouts, does not comply with the structure of presumptive reason? So suppose you have an authority, the authority advises a subject to do something, subject doesn't do it and doesn't bother to explain why not. What's wrong about it? Now, notice that, generally speaking, when you get a piece of advice from anyone, you're not obliged to explain anything, right? People get advice all the time. It's perfectly okay to ignore the advice. You don't have to heed any advice. You don't have to explain yourself. It would be way too oppressive otherwise. So why is it different in an authoritative context? Okay? Why the advice of an authority is something that people should take seriously? Okay? So I think that the answer to that is that legitimate authorities, generally speaking, are warranted in having an expectation of compliance. Yeah? When we have a legitimate authority, the authority can only function properly in its authoritative role only if there is mutual trust between the authority and the subject, and trust of the subjects that other subjects would comply as well. Okay. Why is that? Well, because we certainly don't want to reach a point where the legitimate authority guarantees or gets to the point of having reasonable level of compliance by terrorizing or intimidating the subjects into compliance. We know that it exists, but we don't like it for good reason. So an authority can only function if there is a high level of trust that what the authority directs, people would normally comply with, what they would normally do, right? Otherwise, the authority would have to engage constantly with monitoring compliance, and you reacting punitively to non-compliance. That's not a healthy state of affairs. Again, assuming, of course, the authority is legitimate. So what goes wrong with flouting an authoritative advice is that it betrays this level of trust between the authority and subject. Okay? So in terms of this relationship of trust between authorities and subjects about compliance, there is no difference whether the authority issues a straightforward directive or just an advice, an authoritative advice. Flouting either one betrays this level of trust that is needed in order to allow the authority to function properly. Okay. Anyway, my main point is that authoritative advice is a form of presumptive reason. It requires the subject to do something, or if they think that they ought not to do it, explain to the authority why not. Right? Do or explain. And my claim is that soft law, vertical soft law, is a form of authoritative advice. Now, I want to exemplify it from international law with a particular case, just to give you a sense of how it translates to reality. Okay? So, in the early 1990s, and this is really just one example, I can give more if you like in the Q&A. In the 1990s, early 1990s, the United Nations General Assembly issued a series of directives which were aimed to reduce very significantly a very harmful type of fishing in the high seas called drift net fishing. Drift net fishing was extensively used by many, many countries, by fishing companies in many countries, and it's extremely harmful to the environment. And it really, in most cases, a terrible way of doing things for fishing. So the UNGA, the United Nations General Assembly's agents, conducted very extensive scientific research. They had ample evidence showing that drift net fishing is a very bad idea. And they issued a series of, in several stages, of directives aiming to eradicate drift net fishing. However, the UNGA, the United Nations General Assembly, does not have the authority to issue obligatory directives. It doesn't obligate anyone. So all these directives about drift net fishing were soft law, right? Were non-binding resolutions of the UNGA. So what was the point of it? Okay? What did those directives do? Well, they did two things, two main things. And it's very clear from the text of the directive what those two things. One is they wanted to make the issue salient, public. Right? The directive even required the Secretary General of the UN to make sure that the directives are internationally publicized and everybody knows. So the idea was to point out that there are serious reasons to stop the drift net fishing. However, the directive very explicitly recognizes that those reasons to stop drift net fishing are defeasible. There are certain cases in which they should be allowed, right? So the resolution made it explicit that the reasons against drift net fishing are defeasible. However, it also made it very clear that it shifts the burden of proving that drift net fishing in a certain case should be allowed on the states that want to engage in it. Yeah? So I'll actually read you. It's interesting. I'll read you the language. So the resolution made it explicit that the reasons against drift net fishing in the high seas are defeasible, saying such, quote, such measures will not be imposed in a region should effective conservation and management measures be taken. Okay, so the UN says, we understand that in certain cases it's okay. However, it also said that the burden of providing the defeating reasons on non-complying states, requiring defeaters to be based on, quote, sound analysis to be jointly made by concerned parties of the international community. In other words, the UNGA resolution about drift net fishing clearly has the structure of do or explain. Either stop drift net fishing, or if you think that you should be allowed, prove to the international community, right? Prove to the General Assembly that, in your case, those reasons are defeated. Which is, by the way, interestingly, what happened, right? So many countries stopped drift net fishing, complied with the resolution. Many countries, some countries, applied for an exemption. They came under a lot of pressure to prove that the exemption is justified, and when it was not, they came under a lot of pressure to stop drift net fishing. So this is a case where soft law ended up being very effective. Okay. So I think that at this point, we have a model, a way of thinking about authoritative, about soft law, vertical soft law, in terms of authoritative advice, and thinking about authoritative advice in terms of presumptive reasons for action, namely the structure of do or explain yourself. Okay. Now, this doesn't necessarily apply to horizontal soft law. Okay. Horizontal soft law is not an authoritative relation between authority and subject. It's essentially a contract. It's a treaty. But the air of paradox, the question about its rationale, is very similar. Okay? We normally think about contracts between the parties as mutually undertaken obligations. Yeah, when I sign a contract with someone, then both of us are mutually undertaking certain obligations. That's usually what contracts do. So the question is, what's the point of a contract? What are we really doing when we sign a contract? It has various obligations, but we say they are not binding. You're not really obliged to do what the contract says. Okay. What's the point of non-binding contract? Okay. Now, here there might be there is a tempting idea, and I've heard this idea. I've got confirmation of this, how tempting this idea is from a number of international lawyers who think about these things. It's tempting to think, well, a binding agreement is an undertaking of an obligation to do something, and the non-binding agreement is the undertaking of an obligation to try to do it, to attempt to do it. So in an ordinary contract, the parties undertake the obligation. In a non-binding contract, the parties say, look, we can't really undertake the obligation to do it, but we will try, we'll attempt to do it. Okay? Well, it's tempting, but it's wrong. Okay? That cannot be the rationale of non-binding agreement. Why is that? For the simple reason that an attempt to do something, trying to do something, requires an intention to do it. Yeah? You can't say, I attempt to fly, but I don't intend to fly. That just makes no sense. You can only attempt to do something if you intend to do it. So if you commit to trying to do something, you commit to the intention of doing it. And therefore, a mutual undertaking of a commitment to try to do something without the intention of actually doing it makes no sense. It inevitably renders such contracts profoundly insincere. Right? In other words, if you intend to do it, then you might as well undertake the commitment to do it, might as well acknowledge an obligation to do it. If you don't acknowledge an obligation, then you don't really intend to do it. So I think we need a different rationale. And I think that the idea of presumptive reasons takes us halfway through that rationale. So the way I suggest we understand the non-binding agreement is by seeing it as comprised of two elements. One is what parties are doing. They are acknowledging presumptive reasons that apply to them. They are acknowledging that there is a reason to do something, that the reason might be defeasible, but if it is claimed to be defeated, then the relevant party has to prove that, has to show that that is indeed the case. That's one element. The second element is mutual accountability. Contracts always create a relationship of mutual accountability between the parties. Yeah. So non-binding agreement is a commitment to either fight or demonstrate to the other party that fying is defeated, and the contractual relation makes it the case that each party to the contract is answerable to the other party. Now, why is that answerability? Why is that accountability important? Well, it's important for the following reason. It's not enough that people have reasons for action, whether presumptive reasons or obligatory reasons or whatever. Not complying with a reason is not something that automatically, as it were, invites anyone's criticism or anyone's intervention. Yeah. People don't normally need to answer to others when they fail to comply with a reason for action. There has to be a standing to require or to criticize someone for not complying with reasons that apply to them. Otherwise, the appropriate answer is, it's none of your business. Right? So in the case of vertical soft law, the accountability is something that comes with the relevant authoritative relationship. Right? Authorities are always in a position to require accountability of the subject. They're always in a position to require their subjects to comply with the reasons that were given to them authoritatively. Contractual relations are not authoritative, right? They're voluntary undertakings. But what they create is a kind of accountability relations by agreement, by contract. You know, before we signed the contract, it was none of my business whether you complied with a reason to fire or not. But if we make a contract that you ought to fire, then it becomes my business, right? Even if firing is not to my own benefit. Yeah? Contracts always create this accountability relations between the parties. Okay? It gives the parties a standing to require compliance. Okay, so my suggestion is to regard non-binding agreements, non-binding treaties, as a combination of presumptive reasons for action and establishing accountability relations. In other words, what the parties are doing, right, is acknowledging certain reasons that apply to them. They say, look, we have a reason to do X, Y, Z in order to combat climate change. Okay? So they acknowledge reasons to do something. They acknowledge that those reasons might be defeated under certain circumstances. They might not apply. But then they also undertake the commitment to prove to the other party that non-compliance was justified, was actually defeated in this case. That's the structure, I think, of non-binding agreements, okay, non-binding contracts. Now you might think, and I will conclude with these last few remarks, you might think that this kind of makes horizontal soft law, non-binding agreements in international law, too weak. Yeah, it's not, you know, why bother? I don't think so. Okay, and I'll mention several points. So, number one, when parties undertake a commitment to prove to the other party that their non-compliance was justified, right, to show that it was not justified, they open themselves to criticism and they open themselves to some hostile reaction if they fail to comply with the presumptive reason, if they just don't comply and don't bother to explain, right? So they open themselves to the possibility of becoming under pressure from the other parties, justified pressure, to show, you know, that they need to comply with the presumptive reasons. And it's not entirely insignificant. Think, for example, about the example I mentioned earlier of the Paris Treaty on Global Warming. Yeah. All of it, the whole treaty is soft law. The whole treaty is not binding. And yet it's a big deal. And big enough a deal for, as I guess you know, the Trump administration to withdraw from the treaty. You know, when Trump announced that the US is withdrawing from the Paris Treaty, which it did recently, officially, it's kind of puzzling. Why bother, right? I mean, the whole treaty is soft law anyway. The obligations undertaken by the parties are non-binding. They're not really obligations, right? Quite explicitly. So who cares if you withdraw from the treaty or not? Nothing's going to happen if you don't comply. Well, I think that what the US wanted to signal to the international community is that it does not see itself bound by the treaty, and it doesn't want to be accountable to anyone, right? We don't want to explain. That was the point of it. Yeah. So the need to explain is not without significance, political significance, legal significance. Number two, and that's more of a tangential point, non-binding agreements, especially in the international domain, usually establish a very elaborate and detailed mechanism for monitoring compliance. International standards that everybody agrees to, that would kind of monitor how well parties do in complying with the treaty. And that's important in itself. Again, it has the dual role of affirming the reasons for action that are recognized by all parties and making sure that everyone is on the same page when it comes to monitoring whether compliance was achieved or not. So even if the agreement is non-binding, even if all it does is acknowledges the presumptive reason for action and establishes this relationship of accountability, the fact that it includes very detailed monitoring devices serves this function of both acknowledging the reasons that apply and making sure that there are agreed upon standards of monitoring compliance, which kind of shows that international agents take this idea of do or explain seriously. Even if it's not an obligation, the need to explain that you failed to comply with the requirement is something not without practical significance. Final comment, just to clarify, all this was by way of explaining the rationale of non-binding legal instruments. I'm not suggesting that it's a good idea to have these instruments. I'm not suggesting it's a bad idea. I don't express any views on how desirable it is to expand this notion of non-binding legal instruments. That's a separate issue, and my guess is the answers will be different and varied depending on particular context. Finally, really finally, if you ask, are there non-binding legal instruments in the domestic context, right? All my examples and all my talk was about international law. The answer is fewer, much fewer, right? Most of the legal instruments used by authorities and most of the contracts we sign, etc., are straightforward, obligatory. They're not soft law. But we do find kind of soft law in the domestic context as well. And I wouldn't be surprised if they get more and more used. Later I can give some examples if you want. Okay, I should stop here.
Thank you so much, sir. Before we go to the question and answer round.
Yeah, it would be nice to see who's talking to me. Yes, thank you. I can see you now.
Yeah. Before we go to the question and answer round, I request Charita to start the PPT.
Yes, just give me a minute.
Sure, Charita. Professor, we have made this PPT. Charita has made this PPT for your ease, which has all the questions that have been asked by the participants here.
Yes. Is it visible?
Yes, Charita.
So what's the procedure? I'm presented a question and I answer?
We'll go one question after other, Professor, depending upon your convenience.
Yes. So the question is, how can a treaty be not binding when Vienna Convention states that all treaties must be performed with good faith? Pacta sunt servanda. Pacta sunt servanda is not exactly the good faith requirement, but it's okay. I understand the question. It's just the way things are. I mean, with all due respect to the Vienna Convention, a huge amount of international law these days is soft law. Okay, that's just the way things are. Tons of treaties that are signed, regional treaties and bilateral treaties even, and global treaties like the Paris Treaty on Climate Change are soft law. They state very explicitly that the obligations are not, that it doesn't impose legal obligations on the party. Okay? So, law develops. 19th century, people did not understand that you can have a treaty that's not binding. Things change. That's all I can say. If you want more detailed historical answer to how things change, you will have to consult an international lawyer.
I think we can proceed to the next question, Charita.
What is the difference between authority and power in jurisprudential view? So power is an empirical issue. Authority is a normative one. That's the quick answer. What is power? Well, sorry. I'll rephrase it. Power is ambiguous. Okay? That's one way to think about it. You can have power de facto, right? Power as an empirical fact. Some people just have power over others. And you can have power in the normative sense. Authority is meant as power in the normative sense, and something that ought to be the case, not something that is the case. So let me expand on this a little bit. What's power de facto? Power de facto is, or at least can be measured by, the ability to overcome resistance. Right? I have power over you if I can make you do something that you wouldn't want to do, or I can make you refrain from doing something you would have wanted to do. Okay? The ability to overcome resistance is what de facto power is. Yeah? And it can be big between, lots of parties. Authority is understood normative, right? So somebody is in a position of authority over another. If they're saying so, creates a reason for action, an obligation on the other party to comply. Yeah, that's the difference. We understand authority normatively and power as something empirical, de facto. Okay? And these two things can come together or they can come apart. I mean, somebody can have normative authority without actually having the power, and vice versa. Some people have the power without having authority.
Next question, Charita.
So what is the significance of bilateral agreements over multilateral agreements for conventions, phenomenon in present international law scenario? Not sure what exactly the question is. Not sure what is meant by significance of the difference. But in any case, this is not a question I can answer. This is a question, as I say, I'm not an international lawyer. I don't do international law. That's not my business.
Okay, Professor. Charita, proceed to the next question.
Question number 4 is, how can law and legal practice evolve after this coronavirus pandemic ends? I have no idea. Nothing to do with my talk, with soft law or presumptive reason or anything. What will happen when this pandemic ends? I guess his life will be back to normal. We hope. Okay, that's something I want to answer. So the question is, why? I don't. Does everybody get to see the question?
Yes, Professor. Yes, Professor.
Okay. So I don't need to read it. There's a legal issue here, and there is a kind of practical realpolitik issue here. Okay, so the simple legal answer is, why can't the UNGA issue binding resolutions? Is that it just can't. It doesn't have the authority. Okay, UNGA resolutions are generally non-binding. That's the law. That's how the UN was established. The only binding resolutions of the UN that can come are from the Security Council. Security Council resolutions can be binding. The General Assembly resolutions are not binding. That's just the law. But soft law comes not just from the UNGA, right? There are lots of international authorities that issue directives that are non-binding. And as I said, there are lots of treaties that are not binding, most of them recently. So there's a question of why, right? Why would an international agent or a number of international agents, why would they engage in issuing directives or signing contracts that are non-binding? Sometimes the answer, like in the case of the UNGA, that it's a second best. They don't have the authority to bind, so at least they try to achieve some good by non-binding resolution. It's a second best solution. But not always, not always. Sometimes international agents and international authorities issue non-binding resolutions because they want to kind of gauge the international community's willingness to comply. Yeah. Remember that international law, as sophisticated as it can be, has extremely limited enforcement abilities. Right? They don't have the police to send over and force states to comply. So it sometimes makes a lot of sense to put out there a non-binding resolution and kind of putting pressure on states to comply, to kind of gauge compliance and then maybe adjust the resolution according to how states react to it, and so on and so forth. So it's not always a second best. Okay? Sometimes it's a very clever way of kind of gradually achieving a major change in international law by first issuing non-binding resolutions, seeing how people react, and if everything goes well, trying to turn it into a set of binding resolutions. Okay. Okay. Is there anything about soft law that goes against the basic ideas of positivism? Yes, is that the question? I don't understand. Well, why do I care about soft positivism? So I'm not sure I understand the question. Considering that positive tradition is based on command, it's not. One idea that has been proved to be wrong. To what extent can soft positivism accommodate soft law? Why would soft positivism be in a particular position here? Let me see what I can say about positivism. The idea that law is a command is a 19th century idea and clearly false. H.L.A. Hart spent 2 or 3 chapters in his book showing why it's false, and I think everybody got totally convinced that Hart is right. The law is much more than command. Command is just one tiny fraction of the law. Criminal law looks like command. Don't do this or else we'll put you in jail. But most law is not like that. The vast majority of laws are not like that. So I don't think that legal positivism is wedded to the idea that laws are commands. Some version of legal positivism, the one that I largely support, is wedded to the idea that law is essentially authoritative. Okay? That laws are authoritative directives. And what makes a theory positivist is not this, but the idea that what counts as the legal authority, who has the authority to issue directives that are legal, is essentially determined by certain types of social facts. It's not a matter of morality, it's not a matter of what ought to be the case, but it is a matter of what is the case in every society according to its social norms or conventions. That's what makes a view positivist. Okay? Now, if I'm right that authorities can not just issue obligatory directives, but can also advise, and this authoritative advice is a kind of meaningful instrument, then positivism has no problem with soft law, right? So I don't see that anything I said goes against the basic ideas of what positivism is.
Here's the next question.
Well, I'm not sure I understand this notion of vanishing point of jurisprudence. It's a nice metaphor, great poetry. Not sure what it philosophically means. And I'm not in the business of poetry. Poetry is not my strength. But I kind of understand the idea. Look, there is an ongoing debate about the question of whether international law, public international law, is really law. I find that debate incredibly uninteresting. Yeah. We understand the differences between domestic law and international law. We understand that domestic law has certain features that international law lacks, and vice versa. International law has certain features that domestic law lacks. Okay? So we understand that they are not the same, right? We understand that in many ways, domestic law is more effective, right? It can be enforced in ways that international law cannot be enforced. Yeah. All right. Now, why does it matter if it's really law or not really law? Law is not a natural attribute of things. Yeah. It's a way of conceptualizing the world. It's you know, an aspect of our social reality. Yeah. It doesn't have to have very clear boundaries. So
I think we can go to the next question, Professor.
just one more sentence. It's like asking whether an uncomfortable chair is a chair. Yeah. We can talk about it for 2 weeks. Cool.
That's a wonderful way to answer. Thank you so much. And next question, Jerika.
I'm assuming the way I'm reading this question is that it's an empirical question, right? And I don't have the answers. I'm sure some people do. I don't. But I'll say something about it. So there are all sorts of ways in which various practical authorities can function better or worse, right? Many factors that determine how effective in the real world the action of practical authorities is. Now, in the context of soft law, yeah, there is actually a very extensive research, empirical research, trying to figure out under what conditions soft law tends to be effective and under what conditions soft law fails. Yeah. Most of this work is done not in the context of global treaties. I mean, some, yeah. A lot of it is done in the context of international tribunals. There are lots and lots of really interesting international tribunals, often regional. The number of states in a certain region establish an international tribunal that adjudicates conflicts between states and corporations in certain specified areas. Okay. And there is a lot of research on trying to figure out why some of these international tribunals are very successful, right? They have a high level of compliance and other international tribunals not. So there is a lot of work done on that. That's not my expertise, so I can't tell you, what are the conclusions or tentative conclusions of these empirical researchers. But it's a question that a lot of people pay a lot of attention.
Next question, Charita.
Good. So you're right that the WHO is not exactly an international authority, right? It doesn't issue directives. It issues really kind of straightforward advice. So it's kind of rather soft law. Yeah. And there are borderline cases of soft law like that. WHO is not unique in that respect. And it's, all I can say, it's an interesting phenomenon. And it's something that is very familiar in international law, that you have these agencies, sometimes much less formal than the WHO. WHO is international authority in some respect because it's established by an international treaty that most countries in the world are signatories of, almost all. So it has some legal, formal international standing because it's treaty-based. But you're right, it has extremely limited, almost no authority to issue any directives, whether binding or non-binding. It does have some authority to act in certain cases. Now, there are even more borderline cases. So there are voluntary organizations that issue guidelines in a certain specified domain. And sometimes those guidelines have enormous impact on regulatory schemes in domestic context. So there is a famous committee, it's called the Basel Committee on Banking Regulation or something. Totally voluntary. It's not established by treaty. It has no formal legal standing. But it has a great deal of practical authority. Its guidelines are really almost like soft law. And it's kind of borderline soft law. And it's really interesting. Yeah. So international law is quite interesting. There are a lot of things going on there that you don't find in the domestic context.
Next question, Charita.
So yes and no. I mean, it is the case with every practical authority in any context that there is always the moral question, is that authority legitimate? Yeah. Some states have legitimate moral authority in their legal regulation and some states don't. So the question of what makes a practical authority legitimate is a big one. And it's always relevant. Yeah. not every legal authority is morally legitimate. That's clear. And I think the same applies to non-binding agreements and non-binding authority. There's always a question of whether it's morally legitimate or not. And we can't just give a general answer to all cases, right? It goes case by case. So, of course, I don't want to deny that there are certain principles, moral principles, that apply in the international domain, regardless of any authority or regardless of any legal standing. And the obligation to share research and products of fighting this damn pandemic clearly is, I think, a sound moral principle that states and the international community should comply with.
Next question, Charita.
I cannot say that I understand the question. What's a contract theory to bridge the gap between ideal and reality? I really just don't understand. I mean, the gap between ideal and reality.
We'll skip it, Professor. There are a few other questions which are there in the chat box. Charita, can you read these things? You're on mute, Charita. You're on mute.
Just give me a minute, I will share it.
Sure, sure.
I am not seeing anyone. Yeah.
Okay, we got it?
Yes.
Yeah.
I'm not sure I know what's unsound authoritative advice, except the general idea that not all authorities are legitimate or justified. So I'm not sure what's being asked here. The mask wearing requirement varies enormously in this country because the authority is not federal. The authority goes by state. And states have different laws and they exercise their legal authority in different ways. So all these regulations in response to the pandemic in the US, almost all of them are at state level, and they're not soft law. So when the politician, be it the governor or president or whoever, comes out and says, everybody should wear a mask, or everybody should do this or should that, it's nothing more than just somebody advising us what to do. In the legal form, when it's a legal directive, at least in this country, it's a binding resolution. It's not, it's like ordinary authoritative resolution, and it's backed up by enforcement mechanism and so on and so forth. So truth is, I don't see soft law in the context of these pandemic resolution. It's either not law at all, just advice, or or else it is law in the standard non-soft sense. Whether it's sound or not, that's a separate issue. So, not sure what's being asked here again. Soft law can take two forms. It's either top-down authoritative directive or a treaty, a contract. Yeah, they are different. What I try to explain is that in the core, in terms of practical reasoning, they have the same structure. They both embody this idea of, or instantiate this idea of presumptive reasons, do or explain, in different ways. But there are just two ways in which we encounter soft law in the international domain. What is your view on legal status of soft law? As I said, I don't want to spend any time on that question. I don't think it's an interesting question. Again, it's like asking whether an uncomfortable chair is a chair. It's an uncomfortable chair. Yeah. I'm sorry, I don't understand what the question is. Can we say that authoritative approach? I don't know what's an authoritative approach. Either there is an authority or not, and we can have different approaches to that. Soft law is obligated. I'm sorry, I don't understand the question. I'll skip.
Thank you, Manasi, can you take over?
Yes, sir. Due to the paucity of time, we won't be able to take any more questions. Biola, sir, could you take over for the thank you note?
It is an honor to propose a vote of thanks to an event which was attended by people from different parts of India and also from different parts of the world. And to start with, I should thank Professor Andre for making it convenient. I somehow made it a bit inconvenient for him because of a time zone difference. So he was gracious enough to adjust it to suit our time. Thank you so much, Professor. Thank you for agreeing to deliver a talk for the benefit of our students and also helping us to make it public. Thank you so much. I mean, you are a great teacher indeed, because you had agreed to do it just with an email. Thank you so much for that. And I take this opportunity to thank our Vice Chancellor, sir, for permitting us to host this event. And I personally bring it before you that sir tried to join, but he has a network issue, so at the last moment we couldn't get him online. I thank our in-charge registrar, Professor of Eminence, Bhavani Prasad Panda sir, for taking up the role in a very short notice. Thank you so much, sir. I thank all our teachers, students, and all the people who had attended for their gracious presence here. I presume everybody had learned something today, and that accolades are meant for Professor Andre. Thank you so much, sir. And I thank the three students who had helped me in organizing this lecture today. And last but never the least, our IT department, Mahesh Anna, Santosh Anna, and the whole of the team for making it convenient to have it. Even at an odd time. One of them is still in the campus managing all the things while we are safely sitting at home. Thank you so much to all the people who had supported us. Thank you so much, Professor Andre. Keep inspiring people like us to learn more. Thank you so much.
Thank you very much for inviting me. It was a pleasure.
It's our pleasure, Professor.
Thank you.
Thank you so much, Professor.